Your Honor granted their motion to suppress evidence. So because of that caveat, we do not have to file a motion. The stay is automatic. No, Your Honor.
Anything else on your end?
I will look at 92407.
Now, stay the case against each defendant upon his application order was made until the appeal is determined. That's in subsection 2. And then...
So, if you like me, you curious about what the hell was that about? Let's get into it. The ASA, Alexandra Buckaloo, and the state argued that nothing should be going on until the appeal process is complete at Friday's hearing, while YNW Melly and the defense filed a motion to set aside stay with the Broward County Clerk on Thursday, April 25th, to request the continuance of the discovery process of the retrial. Thursday's motion was filed by Raven Liberty. Judge Murphy III made no decisions and told counsel the motion will be taken under advisement, ruling pending. Now, here's the actual paperwork right here. Comes now the defendant, Jamel Dimmons, by and through undersigned counsel, and moves this court pursuant to Rules 3-190, Florida Rules of Criminal Procedure. I'm not going to read all of that crap. Setting aside Florida's Rules of Appellate Procedure to issue an order setting aside the stay issued by the court on January 26, 2024, and by modifying said stay allowing discovery to proceed in this case, in this cause, as grounds for this motion. The defendant states the following. On January 26, 2024, this honorable court granted the state's motion for stay. Undersigned counsel has not been able to locate court records filed with this court requesting a stay. If that's the case, then pursuant to, we're just going to say Florida law, the state issues that this court wasn't properly issued. Said rule provides a party seeking a stay, a final or non-final order pending review, first must file a motion in the lower tribunal. Therefore, if undersigned counsel's search is correct, it is improper for this court to grant the stay as there was no motion filed in the lower tribunal. Should undersigned be incorrect and a proper motion was filed in a lower tribunal, this court, pursuant to Florida law, has continuing jurisdiction in its discretion to grant, modify, or deny such relief. Therefore, this court has jurisdiction to modify the stay that was issued on January 26, 2024 to allow the defense to proceed with discovery, including taking depositions, motions to compel discovery, and all matters surrounding discovery. Should this court agree with the defendant's position that the stay was improperly entered by Florida law, would allow for discovery to proceed in the absence of a stay during pendency of a review of a non-final order, the lower tribunal may proceed with all matters including trial or final hearing, except that the lower tribunal may not render a final order disposing of the case, the cause pending such review, absent leave of the court. Florida law, therefore, whether a stay was properly put in place or whether it was not, this court certainly has jurisdiction to amend the stay or declare it not having any effect as it was improperly rendered and allow for discovery to proceed. Wherefore, the defendant requests this honorable court to grant this motion whether the stay was entered improperly and has no effect, or in the alternative, to modify that stay and allow for discovery to be completed. So basically, the state filed an appeal based on evidence they previously couldn't use because it was considered hearsay. Since it's still hearsay, it's unlikely the ruling will change in the higher court. Also note, this evidence is not significant. The meat and potatoes of this case is phone GPS evidence, not this. Meaning Melly remains in custody awaiting another trial. Even though he wasn't found guilty in the first one, this appeal process could drag on for about a year. The state does not want to address other matters until this appeal is settled. So, if the state successfully avoids addressing motions for now, after the appeal is finally done, all the motions are done, and jury selection, Melly could be awaiting a retrial for about another 2 years, not to mention Melly already spent 5 years in prison awaiting the first trial. How is that constitutional? It appears the state is more interested in delaying the process than actually processing Melly. Given the lengthy wait without resolution, it seems reasonable for Melly to at least be granted a bond. He's already served 6 years, will likely end up being more for a crime he hasn't been convicted of.
Yeah.
We are on appeal because Your Honor granted their motion to suppress evidence. So because of that caveat, we do not have to file a motion. The stay is automatic. No, Your Honor.
Anything else on your end?
I will look at 92407.
Now, stay the case against each defendant upon whose application the order was made until the appeal is determined. That's in subsection 2. And then...
So a stay basically means we got to put a hold on the court until we figure this out. Now, like I read in the other spot, basically they're trying to say, oh, we got to see if we can approve this and approve that. I think the state is playing a dirty game. Oh, Seti Nash, you go accusing states of playing dirty games. Bruh, they saying that this could take up to 2 years before this trial actually starts. This gonna sound messed up, but it sounds like around the time that Young Thug, his verdict comes through, we'll be starting up with the YNW Melly trial. Gonna be a little wild. Now, what they're trying to do is trying to get something that they hadn't been granted before, that the judge was like, no, y'all can't use that. It's hearsay, that's hearsay. And they're trying to still use it. So that's what it is. And it's not like, once again, it's the important thing. So we'll see, bruh. If what they're saying is true, they're saying basically that when they filed the stay, when the state had filed their stay, that basically they went to the wrong court. Like, y'all started it wrong. It's like, it's levels to this, basically. Is the easiest way to put it all. But other than that, we gonna see, bruh. I found out they moved Melly to another jail, so he's not in the Broward County jail. And that's pretty much it, bro. I don't know what the hell they got going on, but the fact that I think they may be pissed that they lost, and because technically you didn't get a conviction, you got a mistrial. Y'all didn't. This is supposed to be a walk in the park, and your head prosecutor is now off. And I don't know if that's a good thing or bad thing, because I feel like she was tone deaf and she really didn't kill it the way she should have killed it. But we'll see. This might be their way of essentially trying to get her up to speed. It's a hell of a thing, because if that's the case, then they're basically training her to be how the DA was supposed to be, and she wasn't ready. That's how I see it as, honestly, is that she ain't ready, and they trying to figure out any way that they can to delay this. But y'all let me know if you don't see this video at 4K likes. Then that lets me know y'all ain't feeling this YNW Melly stuff, not on this channel, so we'll push it over to the other one. I'll catch you on the next one.